Okay, it's 3 o'clock. We'll go ahead and get started. Good afternoon, everyone, and welcome. My name is Fanny Rodriguez Melnikovsky. I am the state ombudsman, and I've been in this position for about a year. And I would like to welcome you to our long-term care ombudsman virtual council meeting. Just a little bit about myself. I've been in long-term care for over 20 years. 10 of those years I spent as a nursing home administrator, and I also held other positions during that time. I also worked in the hospital in case management and operations. Our state office operates under the Idaho Commission on Aging. The Idaho Commission on Aging is a state agency that provides services for aging Idahoans. Some of the services include adult protective services, caregiver support, nutritional services, such as home-delivered meals and congregate meals. They also offer respite care and fraud and prevention scam training. Under federal law, family members in long-term care facilities can join together to form United Family Councils. This is a forum for families to bring up concerns to leadership about any care or quality of care issues. Part of the Ombudsman program requirements is to provide education and training and resources to families, residents, and the community. The purpose of our Family Council statewide virtual program is to provide information, resources, and education related to long-term care issues that are empowering families and communities to advocate for better quality of care and quality of life for residents in long-term care. We are very excited to have you today, and thank you again for your support. And I hope that you enjoy the presentation and find value in it. And now I will hand it over to Sherry.
Good afternoon. As Fanny said, welcome. I'm Sherry Young. My role is Family Council and Volunteer Coordinator for the State of Idaho Long-Term Care Ombudsman Program. We will be hosting these meetings on the fourth Wednesday of every month. We host these meetings to empower and educate families and residents on all aspects of long-term care. Please note, these meetings will be recorded and uploaded to YouTube. Just Google Idaho Virtual Family Council and you can easily locate them. We will start with our presentation and then open up the meeting to questions. All monthly meetings will use the same Zoom link and QR code, which makes it really easy to find. Please join us on all of these monthly meetings. I think they're going to be great with a lot of important and meaningful information. Let everyone know so that they can join along with us. Before we begin, let me cover a little bit of housekeeping. Reminder, please refrain from using your name or the name of your loved one. Please do not name specific facilities. Please use the terms nursing home, assisted living, or personal care home to present to the group. If you do need specific assistance, please use the chat feature to state the county that you are in, and we will have an ombudsman reach out directly to you. The calls have public access and are designed for family members, as well as friends and family members of those residents in long-term care. Some virtual meeting tips. You've all been placed on mute upon entry. We will open the lines in a bit, so they'll be able to speak. If you have a question, please use the raise hand feature. Once we've completed our presentation, we will open the meeting to questions. The chat feature is at the bottom of your screen. As well, once you maximize it, you will be able to ask questions to the chat moderator or others during the call. Any concerns or complaints you have can be directed to Fanny Rodriguez Melnikovsky at the State Ombudsman Office. And now I want to introduce our speaker today, Emese Maynard. She is the Guardianship and Conservatorship Coordinator for the State of Idaho. Emese?
Yes, hi everybody. Yeah, my name is Emese. So I'm the Guardianship Monitor for the 4th District here. So I have 4 counties, Boise Valley, Elmore, and Ada. And then in each one of the judicial districts, there's a coordinator. So there is 7 of us. And I can, if you're in a different part of the state, if you reach out to me, I'm happy to direct you to that person. Let me see if I can share my screen because I have several screens, so I do apologize for that. So again, I am the 4th Judicial District Guardianship and Conservatorship Monitor. I am located in Boise. Our program was created by the Idaho Supreme Court in 2017. And it was basically created because all of the guardianship cases in the state at that point were not very well monitored. They had to go through the legislature. Obviously, they approved the positions. So me and my 6 colleagues throughout the state were hired for the positions. I have to move this. Okay. Our purpose is to provide help for the public. We get a lot of phone calls regarding, you know, I have a family member who needs help. How do I become their guardian? So we provide a lot of information for the process of becoming a guardian to family members, members of the, you know, public who have loved ones, friends that they have concerns about. We flag problem cases and notify the guardian ad litem attorney on those and notify the court and hand it over to the court at that point to decide what would be an appropriate action. Also, our program goal was to establish consistencies in case processing, annual reports and delinquent notices throughout the state. Prior to 2017, a lot of counties were doing a very good job, but it was just not consistent. So since we started, we've been working on, you know, making sure that everybody is reporting and that we're collecting the reports that are required by statute. Let's see. So today, I was just going to talk about adult guardianships. On my caseload, I have minor guardianships. I have adult guardianships. We generally have 2 different types of adult guardianships. One would be for a developmentally disabled adult, and one would be for an incapacitated adult. And I think that the best to talk about today would be the incapacitated adult cases. Here on the slide, I've noted the statute. We are under the probate code. So if you just plug it in your internet search, whatever browser you use, you will be able to pull up the statute and kind of read through it if that's something that you're interested in doing. So like I said, the adult cases usually 2 different types: developmental disabled adults, where the disability occurred prior to the age of 22, and then the incapacitated adults. I'm here to talk again about the incapacitated adult cases. The most common situation with those is usually adult children having to become guardians or conservators to their parents due to their health issues, their aging. They may have some type of dementia. They may have some type of mental illness or a progressive disease like Parkinson's disease or something like that, where their ability to make decisions is diminishing. And unfortunately, there is no hope that the situation will improve. They're just going to need more care as time passes. I was going to talk a little bit about the process, what the process is to become a guardian in the state of Idaho. Unfortunately, as of right now, the court does not have paperwork for public members. We cannot give you a petition that you can fill out and bring to the courthouse and file. Everyone who calls me, with oftentimes it's the same question. My mom, my dad, my aunt, my uncle need help. How do I become their guardian? I have to tell people that they have to look for an attorney in the community. I am well aware that it's a very expensive process. But as of right now, again, we do not have any type of paperwork that we can provide. I always tell people try Idaho Legal Aid or Idaho Volunteer Lawyers and see if they qualify for some of the criteria that they have. But as of right now, unfortunately, it is what it is. We don't have paperwork to give out to parties. So I was just gonna walk you guys through the process of becoming a guardian. It could take a couple of months through the court to be appointed. Usually the petitioner, who is the person, not always, but most of the time it's the person who would like to become guardian or conservator to the protected person. Their attorney will file a petition with the court. At that time, the court will appoint a guardian ad litem attorney to represent the best interest of the protected person. They will also appoint a court visitor. Most of our court visitors are counselors or social workers from the community who have a lot of experience working with vulnerable population, and then they will also appoint the physician. So between the guardian ad litem, the court visitor, and the physician, each one of them have to submit a report to the court with what their recommendation is, if they feel that the person needs a guardian or not, and whether the proposed guardian is appropriate to act in that capacity. And then the proposed guardian will have to go through background checks through the Department of Health and Welfare. They have to be fingerprinted. And then the Department of Health and Welfare sends those results to the court as well. Once all of the paperwork comes together, at that point, there is usually a hearing where the judge will appoint a guardian, and letters and orders will be signed. You can get temporary guardianship that lasts 90 days if there is some sorts of, situation where it's an emergency and, someone is being exploited or taken advantage of by someone, or they need medical decisions made immediately. There is an option to get that temporary 90-day guardianship or conservatorship in place until the permanent appointment happens. I don't have an exact timeline, but it does take a good few months to get, all of the paperwork into the court and then schedule an appointment hearing. So once a guardian or a conservator, and I apologize, I should have actually clarified this, but a guardian in the state of Idaho is a person who will be making decisions for the protected person about their persons, doctors, where they will live, what type of contracts they can enter, what kind of services they will get, those type of things. And a conservator in the state of Idaho is someone who will be responsible handling the protected person's finances, money, their estate, those type of things. So in some of the states, it's a guardian for guardian and conservator, but in the state of Idaho, it's two separate things. You can be guardian and conservator appointed in the same case, so they don't have to be separate court cases. Sometimes you just want to be guardian, sometimes you just want to be a conservator, sometimes you want to be both. It depends on each family's situation and what's going on with their loved one. I will take a sip of water if that's okay. So once the guardian is appointed, they will have to report to the court annually. There is statutory requirement to file status reports. The first report that they will have to file with the court, that is called a 30-day care plan. That's basically, as the name suggests, what are your plans for the protected person? Will you be moving them? What type of services will you sign them up for? Do they, what are their wishes? How will you honor that? Those type of things. And then a conservator has and then a conservator will have to file their own report as well. So the guardian's annual status report will have to be filed every year. It is due at the anniversary of the appointment. So if someone is appointed March 1st, 2024, then they will file the 30-day report in the next month. And then after that, between March 1st and April 1st, there's the 30-day grace period given. They will be filing a report every year between March and April for 2025, 2026, and so on until the case is terminated. Oftentimes, the cases terminate when the protected person passes away. There are standardized forms for the Guardian's annual status report. It is available from the Court Assistance Office. It is available on the Idaho Supreme Court's website. We do recommend to use those forms because those forms were created in compliance with the Idaho Court Administrative Rule that outlines what are the questions or what's the information that the guardian is supposed to give the court. So we do recommend that parties use those forms. All right. So the reports are read by me here in the 4th District. In all the other judicial districts and throughout the state, again, there is a coordinator, just like me. We all have the same job, and the majority of our job is taken up by reading the annual status reports. So it is supposed to provide a comprehensive overview of the protected person's well-being, their living situation, their mental, physical, and social situation, the guardian's contact and actions on behalf of the protected person, what type of changes have occurred in the capacity of the protected person, and whether the guardian or the protected person feel that there is still a need for the guardianship to continue. Again, it's Idaho Court Administrative Rule 54.2. You can look it up on the Idaho Supreme Court's website that gives the requirements of what the information is that the guardian should be providing for the court. So I read all of those reports in my district, and I submit a review memo into each file, whether I find that compliant or not. If it's non-compliant, it is going to be sent to the judge's attention. Generally, they're non-compliant because someone is talking about wanting to terminate the guardianship, or because they are just not filling it out in a way where I am able to grasp how that protected person is doing. You know, if you're submitting blank reports, if you're just writing not applicable as an answer to each question, it's probably going to be non-compliant and sent back to you. And we would be requesting that a new report is filed with the court, giving us the information. So I'll move on to a little bit for conservatorships. A conservator, like I said, they take care of the finances and the estate of the protected person. They are also required to file annual reports with the court. Within 90 days of their appointment, they will have to file an inventory and the financial plan. And this document is also a standardized form that the court has available for the conservators. And this is basically the starting point for, it's an inventory, it's a starting point for all the financial accounting. So usually what people will do is they'll list everything that the protected person owns, whether it's a home, whether it's cars, jewelry, firearms, recreational vehicles, whatever you have, you know, collections of different things, if they were collectors of different items, and then they put a price tag on those things. Is there a question? Okay. And again, this will be submitted 90 days after the appointment, and then every year after the appointment, just like the guardian, the conservator is required to file a report with the court on how they are handling the protected person's money. It's depends on the size of the estate. We have two different forms for that. One is the 50,000 and under, and then one is for larger estates, but it's basically what the money is coming in for the protected person's income, and then what money is going out paying for the care, the residence, or whether it's a care facility, it's an assisted living facility, wherever they're living. And then all of their other, bills, what goes out. And so that is actually reviewed by the Idaho Supreme Court. Their finance department reviews every accounting that's submitted in the state of Idaho. And they pretty much have the same process as I do. Once they go through it, they always compare it to the previous year and then what the inventory values were. And then they will file a review memo with the court. If it's non-compliant, it may be sent to the judge for review, or sometimes they're just really asking for some additional documentation. They like to see bank statements and different things like that, or financial statements that verify the income and the bank accounts that people put on the accountings. They do have to follow a specific time period. It's because they go from the appointment, and that could be any time in the year. So they don't follow the calendar year. They always go from appointment to a year out. So that's the time period that they always have to follow. And again, supporting documents, they usually ask to submit those. If anyone is interested in learning about what a conservator is required to report on, again, it's Idaho Court Administrative Rule 54.3. You can look that up on the Idaho Supreme Court's website. And it gives you a pretty good detail for guardian's report as well as conservator's report. I think I've touched base on this. So again, I review the guardian's annual status reports. The Idaho Supreme Court will review the accountings, but people are not aware that we are reading these reports. So you're not just submitting it where it goes into a file and kind of no one ever looks at it. Rest assured that every one of them in the state is being read by the guardianship monitors. So again, for when I review a report, and I think that the finance department does similarly to my criteria, we are looking for information. If you are submitting duplicate reports, some people will make photocopies and they just change the year on it and they submit it year after year. Those will be kicked back because we want updated information on the protected person. If they're leaving questions unanswered, if we are finding criminal records for the guardian or the protected person, we send those to the judge's review to decide if they need to have a hearing or if they need to get the guardian ad litem attorney or anything like that. And then if people report on the annual status report that they wish to terminate the guardianship or the conservatorship, we usually reach out to those people. When I reach out on those, I usually tell parties to call the guardian ad litem attorney and then talk to their own attorney, because there is a process to terminate the cases. You have to petition to the court, just like you have to petition to have someone appointed. You have to petition to terminate the case, and usually the guardian ad litem attorney has an opinion whether it should be terminated or not. They may ask for updated reports from the physician, whether the person's condition has improved, where they are able to make decisions for themselves again. So there is some criteria that parties have to meet to terminate the case. And then the financial reviewers, again, they're looking for missing assets. They are looking for verifying bank accounts. they are looking to make sure that the protected person's money income is spent on the protected person's own benefits, and that monies are not commingled with the conservator's money. And there is a class that people do have to take before they are appointed, and it does a pretty good job explaining what your roles and what your duties are as guardian and conservator, and what you can and cannot do. And that's through the Idaho Supreme Court's website. Excuse me. So the guardian's roles and responsibilities, it is to allow the protected person to participate in decision-making as fully as their abilities allow. That's kind of it. I always tell people, you know, to honor the protected person's wishes and help them make decisions, no matter how small that decision is. It's important that they are able to participate to their abilities. The guardian is also to assist the protected person in meeting the essential requirements for their physical health and safety, in protecting their rights, in managing their financial resources, and in developing or regaining their abilities to the maximum extent possible. Again, if there is any kind of therapy that's available that will help that person regain, you know, some of their abilities, there is so much stuff available. You know, we always encourage people to make those decisions and help the protected person to be as independent as they can be. Generally, this is kind of a general rule, but the guardians don't make healthcare decisions on sterilization or experimental medication without a court order. So if it is something, I don't know, for example, if you're trying to get your loved one into, you know, like a medical trial or something like that, you do need court authorization for that, and you do want to bring that to the court and request that the judge signs an order on that. The conservator role is to act as fiduciary, to deal with the assets as a prudent man would deal with the property of another. I hope that this is self-explanatory, but it's basically making the best decision that you can for the protected person with their money. A conservator in the state of Idaho may be required to produce bond. That is something that I tell people to talk to their attorney about it. I don't have a lot of deep understanding of what a bond is, but it's basically almost like an insurance type of situation where if the money is mismanaged, the bond would be covering I think the amount that's being mismanaged. But again, talk to attorneys about the bond. I am not sure how they work. I don't know how much they cost. And it's usually up to the judge if they will require the conservator to have a bond or not. The conservator is to manage the financial affairs of the protected person in ways that it is in the best interest of the protected person and their estates. They can pay bills, run a business, they can invest the protected person's money, they can make repairs to a property, they can rent out a property, they can sell a property. I always recommend when guardians or conservators call me with questions regarding that, not only talk to your attorney, but consider coming to the court for a court order. I do know that a lot of families have to sell assets, you know, homes. We've seen people having to sell farmland and, you know, cars and different things to pay for the care of the protected person. If it's something substantial like a home or something like that, I usually tell people that it is always best to come to the court and have your judge sign an order on allowing you to do that. I think it's a cleaner way to do it than sometimes people, you know, get rid of assets and then on the next accounting, they don't show up, and then we will be questioning what happened to those assets and you know, why were they sold. So that's all I kind of have for today. And I am happy to answer any questions that anyone has.